But thank you very much for joining. I hope you're having a good start to the week so far. We are continuing this series on adverse possession, in particular, adverse possession under the Land Registration Act 2002, which I'll refer to as the Act. And today we're considering the question of, is that reasonable? 10 years of reasonable belief ending on the date of the application. Now I've got a problem, it's not going. We have moved to the next screen. So I'll start with an overview of paragraph 5 of Schedule 6 of the Act. Then I'll consider the question of what does ending on the date of the application mean? And then I'll address the question of whether the belief in question is objective, subjective, or imputed. I'll finish with the question of when the belief will be considered unreasonable, and then there'll be some time for questions at the end. So, Schedule 6, paragraph 1(2) provides that a person may apply to the registrar to be registered as the proprietor of a registered estate and land if he has been in adverse possession of the estate for a period of 10 years ending on the date of the application. Paragraph 5 of Schedule 6 then sets out 3 different gateways or conditions which entitle the person to be registered as the proprietor. The first condition, which you can see here, subparagraph 2, is essentially proprietary estoppel. It talks about the unconscionability of an equity by estoppel. The second condition is a catch-all residuary category, where for some other reason, the person is entitled to be registered as the proprietor of the estate. And examples might include where the squatter is entitled to a conveyance of the land under a will or an intestacy, or because he or she has purchased and paid for the land. But today we are interested in this third condition, so paragraph 4, which is the most similar to adverse possession at common law. But as you'll be aware, it is more restrictive, and it essentially applies where the squatter was reasonably mistaken about the boundary. In today's seminar, we're particularly interested in subparagraph 3, C, sorry. And I'm having trouble moving this screen forward. There we go. Which provides that for at least 10 years of the period of adverse possession, ending on the date of the application, the applicant or any predecessor in title reasonably believed that the land to which the application relates belonged to him. Now, this subparagraph can be broken down itself into 4 different elements, at least, all of which differ from the common law rules. So first of all, you must have 10 years adverse possession, with adverse possession meaning the same as at common law, but the period being 10 rather than 12 years. Ending on the date of the application. That is a statutory phrase that has caused a lot of confusion, and so we'll turn to that next. Third is during which the applicant believed that the land to which the application relates belonged to him. And fourthly, that belief must be reasonable. So those final 2 elements are different to the common law, because at common law, once you've proved intention to possess the land, there's no need to prove a reasonable belief that the land belonged to you. Indeed, at common law, the squatter may take possession knowing full well that the paper title to the land belongs to another person. And it may be more difficult to prove intention to possess if you're only inadvertently occupying the land rather than deliberately. So it's different to the common law. Let's turn to this question of what does ending on the date of the application mean? McGarry and Wade comment that one aspect of the third condition remains the subject of uncertainty. It is not known whether the 10 years of reasonable belief must continue until immediately before the date of the application. Clearly, a requirement that S submit her application on the very day her belief ceases, or ceases to be reasonable, is impracticable and cannot have been the intention of Parliament. The wording of the statute leaves it unclear as to whether any period of 10 years within the period of adverse possession will suffice, or whether a reasonable period must elapse between the ending of the belief or of its reasonableness, provided that the squatter acts promptly. Well, it doesn't say much for the clarity of the phrase ending on the date of the application that the Law Commission itself has changed its mind about what it means. In its 2018 report, where it was consulting on the Act after it had been enforced for some time and there was some case law related to it, the Law Commission said, as we explained in the consultation paper, there are three interpretations as to how soon after realizing that his or her belief is mistaken, the claimant must apply for registration under Schedule 6. The first interpretation is that the claimant must maintain the belief at the time of the application. This interpretation would deny the provision any use. Claimants will not apply to be registered based on adverse possession if they do not realize that the land is not theirs. The meaning of the requirement therefore falls between two possible interpretations. First, the reasonable belief must be held for 10 years at any time prior to the application. This interpretation flows from the wording of the statute itself and is supported by commentary and some case law. Two, the reasonable belief cannot end more than a short time before the date of the application. This interpretation is drawn from the Court of Appeals guidance in Zarb and Parry and is also supported by commentary. So in its 2001 report, in proposing the Act, the Law Commission's intended meaning was, it seems, the first meaning that it states there. But when consulting on the Act after it had been enforced, it took a different view. So it says, in the consultation paper, we favored the latter interpretation. Schedule 6 was intended to bring finality to claims of adverse possession, and in particular to resolve these types of boundary dispute. Once the person's reasonable belief comes to an end, ownership should be resolved quickly, and bringing finality to the question of ownership is in the interests of all parties. It would not be in keeping with the policy underlying Schedule 6 to allow a claimant to sit indefinitely on a claim for adverse possession in relation to a boundary after becoming aware that he or she was not, in fact, the proprietor of the land. So for this reason, the Law Commission recommended the introduction of a fixed period of 12 months grace for making the application after a squatter no longer has a reasonable belief that she owns the land. But that is not currently the law. The best statement of the current law is that case referenced by the Law Commission, Zarb and Parry, from 2011. For those of you with a local connection, by local I mean local to Worcester, where I am at the moment, Zarb and Parry was heard at first instance in the Worcester County Court by His Honour Judge Pierce Higgins QC, and it relates to land in Welland near Malvern. This is the front door of the Zarb's house, which is rather attractive, I think, and that's some of their land there, so no wonder they were fighting for it. In Zarb and Parry, the paper title owners of the disputed land were the Zarbs, and they applied for a declaration of the boundary and an injunction requiring the boundary features to be repositioned. The Parrys defended the claim by relying on Section 98 of the Act and the third condition of Schedule 6, Paragraph 5 as a defense. And in that case, Lady Justice Arden summarized the position in this way. The moral is that as soon as the adverse possessor learns facts which might make his belief in his own ownership unreasonable, he should take steps to secure registration as proprietor. If a person discovers that his boundary is in fact on his neighbor's land and that he has been in possession for 10 years, he can, if he acts promptly, apply to the land registry to be registered as proprietor of any land outside his title. So based on that statement of the law, the real test is, did the squatter apply promptly after her reasonable belief came to an end? Now, in Zarb and Parry, there was a sub-issue about whether the Zarbs had brought the period of adverse possession to an end by force, or what we could call the Putin method. Essentially, on a day when they thought the Parrys were away, the Zarbs uprooted the fence, which was in the wrong location, according to them, and they put fence posts along the boundary they contended for. They cut down a tree and marked out the boundary that they were contending for with surveyor's tape. Unfortunately for them, the Parrys were at home and they caught them red-handed. And after 20 minutes of wrangling and calling the police, the Zarbs had to concede defeat and give up occupation of the disputed land and go home. I really do hope that is a metaphor for what's going on in Ukraine at the moment. But the courts held that this temporary act of eviction had not deprived the Parrys of exclusive possession of the disputed land. And so this wasn't a case of what occurs when someone has lost possession of the land. But what if the period of adverse possession does come to an end before the application is made? Well, Schedule 6, paragraph 1(2) provides that a person may also apply to the registrar to be registered as the proprietor of a registered estate in land if he has, in the period of 6 months beginning on the date of the application, ceased to be in adverse possession of the estate because of eviction by the registered proprietor or a person claiming under the registered proprietor. B, on the day before his eviction, he was entitled to make an application under subparagraph 1, and the eviction was not pursuant to a judgment for possession. So since the Parrys had not been evicted, that statutory deadline did not apply. But in some cases it will, and that's a fixed period that is set out in the statute. But it's also a useful rule of thumb, even where paragraph 1(2) doesn't apply. So I would suggest that even if a squatter retains exclusive possession of the disputed land, she should try not to wait longer than 6 months after her reasonable belief comes to an end before making any application. 6 months feels like it's getting to the stage where it's no longer prompt, and that 12-month period that the land registry recommended is not the current law. So there's no fixed period in general, but I have 6 months in mind as a useful rule of thumb. And in terms of practical considerations, the degree of promptitude required will depend on how obvious it was that the reasonable belief had come to an end. So in my opinion, a squatter will be expected to act more promptly in a case where on a certain day it becomes completely obvious to her that she does not own the land, as compared to a case where over an extended period of time, she is increasingly put on inquiry that it may be unreasonable for her to continue believing that the land belongs to her. So I think there are two, you could categorize cases in that way, the first category and the second category. Zarb and Parry fell into the second category, which is why their defense succeeded, even though the dispute over the boundary had been ongoing for at least 7 years before the claim was made. And in fact, the dispute had been raging between the predecessor title of the Zarbs and the Parrys. So I'll return to that later on. But let me give an example of a first category case where it becomes obvious on day one that the squatter does not own the land. So I had a first tier tribunal case where there was a dispute over this patch of garden. My clients lived in this house on the right. The respondents were on the house on the left. They were the paper title owners of the land in the disputed land. Now, if you look at this, my clients had assumed that they owned all of this. So taking the edge of the driveway of the respondent's land going up the pathway towards their back garden. My clients thought they owned all of this, and they maintained the grass and the gravel and all that, and planted these little bushes here, and there was already a flower bed when they bought the land. But in fact, if you look at the paper title, the title plan, the boundary actually goes more like this, follows the line of their wall, cuts across there, and then cuts down parallel with their wall across here. So look at this land registry map. You can see, rather than following the line of the respondent's house, the elevation of the wall there, it cuts like this parallel with my client's wall. And so the disputed land was essentially this bit here. Now, 16 years after buying the land, the respondents looked at their title plan and realized that it did not correspond to the physical features on the ground. And so on the 26th of July 2019, they marched round to my client's house and showed them the title plan. The applicant stated that although they had been on the land for 11 years, this was the first time they had been shown the true location of the paper title boundary, the first time they had looked at the title plan. Now, I put this in the first category of cases because once you see the title plan, it is immediately obvious that it doesn't follow the physical features. And so there's no real possibility of arguing that this was a dispute over land within the general boundary and that it was not very clear. It seems pretty obvious that it follows a dogleg, which is not like the dogleg in reality. So the applicants made an application 2 months and 2 weeks after the 26th of July 2019. Unfortunately, that application was rejected by the land registry, partly because it did not contain a plan identifying the disputed land. And unfortunately, the applicant's solicitor did not realize it had been rejected, and the solicitor subsequently retired. So it wasn't until February 2021, or 2020, that the applicants filed a new application, and that was 6 months and 1 week after they were shown the title plan. Now, in that case, my clients were successful, and Judge Gatti found that the applicants acted promptly in making the application after discovering at the end of July 2019 that they did not own it. They had instructed their solicitors within a month or two, and it was their solicitors, not the applicants themselves, who were responsible for the subsequent delays. I do not consider that in this context, solicitors' delays and/or taking 6 months to issue the application are to be treated as showing a lack of promptitude by the applicants. So that was what happened in that case, and it was quite a battle to persuade the court that that was a reasonable amount of time. It would have been easier if it hadn't been so clear from day one that they didn't own the land. Now, this raises another practical question of how quickly the application should be made. Is it best to file an urgent application with basic details, or spend several months preparing the application and statement of truth thoroughly? I would suggest more speed, less haste. The application must be thorough and accurate without being slow. So if you fill out the form incorrectly, without providing a plan, without getting a surveyor to do that for you, there's a good chance it will be rejected by the land registry and you'll have to start again after a long delay. Even if you fill it in correctly, but you don't set out sufficient detail, or you have perhaps some slightly incorrect dates or facts, which need to be corrected in your trial witness statement, then that will prejudice your application and the respondent's counsel will jump on any inconsistency. So we did have this problem in the trial as well, that we'd set out that the application had set out some basic details in chronology and acts of factual possession and so on, but not in much detail. And so much more had to be added in the trial witness statement and also in oral evidence, and it starts to look as if you're just adding in things ad hoc. So if you can set it all out to start off with, have the full chronology, all the acts that you're relying on, that's much better. But of course, that takes time. And so it's a bit of a catch-22. In addition, you must also devote some time to engaging in pre-action correspondence and negotiation. That's why the Law Commission recommended a 12-month period of grace, because it said that the period of time must be sufficient for claimants to seek to settle the matter with the adjoining landowner, and then to prepare their claim if settlement is not forthcoming. So it would really be desirable if we could have a fixed 12-month period, but at the moment, that's not the law. So it's simply a case of having to act as quickly as possible, but also being as thorough and as accurate as possible. So we'll go to the next question of, is the belief in question objective, subjective, or imputed? So the belief, the applicant must have subjectively believed that the disputed land belonged to him or her. The court will not impute knowledge to the squatter, but the belief must be objectively reasonable. Let's take the subjective element first. And I'd like to refer to the case of IAM Group PLC in Chowdhury, 2012 case. In that case, there were two buildings which adjoined one another, number 26 and number 26A. A historic transfer deed defined the boundary as a straight vertical line between these two houses. However, before the transfer of the land to the respondent, 26A, he had for many years been occupying both 26A and also some rooms on the first and second floors of the applicant's property, number 26. It was a bit of a higgledy-piggledy old building, and so he'd been occupying various rooms which went beyond the straight vertical line. He'd been occupying them under an oral tenancy, so it wasn't adverse possession at that point. He then purchased 26A and remained in occupation of those rooms that were over 26, the ground floor 26. Now, it would have been obvious to him that he did not own any part of 26 if he had consulted the title plan, which matched the historic deed, which had defined the boundary. And the historic transfer deed was also referred to in the charges register. So fairly sensibly, the appellant paper title owners argued that since the squatter had instructed solicitors when he purchased his land, the court should infer that those solicitors had consulted the transfer plan and carried out any necessary searches and inquiries on his behalf. Therefore, the squatter's solicitor knew or should have known that the disputed land did not form part of his paper title. And since the solicitors were acting as the squatter's agent, any knowledge which they had or ought to have had should be imputed to the squatter. Well, Lord Justice Etherton, as he then was, gave the leading judgment for the Court of Appeal, and he held that that was not the case. The court is only concerned with the actual knowledge of the applicant, not imputed knowledge. First question is whether the squatter subjectively believed that the land belonged to her, and secondly, whether it was reasonable for that particular person to have that belief. Now, the problem for the appellant in that case was that the squatter's solicitors firm in question had ceased practice, and there was no conveyancing file in evidence. But in other cases, it may be possible to persuade the court that the squatter did not subjectively believe that the disputed land belonged to her, because during the conveyancing process, she was advised about the boundaries or directed to a transfer plan, etc. And so it's a good reason for getting disclosure of any conveyancing file in this type of case. But it's, and I'll return to the question of the advice that solicitors may give to their clients during the conveyancing process in a moment. But that takes us to the next question of when will the belief be considered unreasonable? So from what I've already discussed, it is clear that the Law Commission and the courts have taken the view that it's not automatically unreasonable to believe that land belongs to you, even if you could have discovered that this was not the case by taking the simple and obvious step of looking at the transfer plan or the title plan and comparing it to the physical boundary features. The Law Commission could have said, look, the purpose of the system of land registration is to ensure as far as possible that ownership of land can be conclusively determined by consulting the Register of Title. So how can it be reasonable to spend your life savings on a registered property without inspecting the transfer plan and title plans? How can you spend a whole decade treating your neighbour's land as your own without checking a visual representation of what exactly you've bought? They could have said that, but that's not the law. It was always the Law Commission's intention that paragraph 54C could apply where the physical features on the ground or the paper title owner gave a misleading impression of the true boundary. And I would argue that's the case even if the title plan and transfer plans are clear. So when proposing the Act, the Law Commission said that the adverse possession condition should apply in two types of case. The first is where the boundaries as they appear on the ground and as they are according to the register do not coincide. This may happen because the physical features such as the position of trees or other landmarks suggest that the boundary is in one place, but where in fact, according to the plan or the register, on the register, it is in another. B, when the estate was laid down, the dividing walls or fences were erected in the wrong place and not in accordance with the plan lodged at the registry. So that's the first category of cases. The second category is where the registered proprietor leads the squatter to believe that he or she is the owner of certain land on the boundary, when in fact it belongs to the registered proprietor. And that would also trigger the proprietary estoppel condition, which I mentioned before. So this does seem in some ways a little unfair to paper title owners, that you can properly register your land with a good title plan and a deed, a clear transfer plan showing the boundary, and yet end up losing part of your land. And it's worth noting that in its original consultation report, before the Act was drafted, the Law Commission recommended that if the squatter succeeded, the paper title owner should obtain some form of financial compensation from the squatter for the loss of her land. So it was actually envisaged that there would be a bit more of a balance in favor of the paper title owner, that yes, you have to give up a bit of your land, but you get compensated for having to do so. But that part of the recommendation was dropped and didn't make it into the final Act. So a paper title owner who loses will not only not get compensation, but will probably have to pay the squatter's costs. Returning to this question of when will the belief be considered unreasonable? Well, as I've been saying, the squatter's belief will not automatically be considered unreasonable if it could have been dispelled by taking basic advice from her solicitor. That was the case in IAM Group PLC and Chowdhury. But the facts, I guess, were a little unusual, because in that case, the disputed land could only be accessed from his land. There was no way of getting to those upper rooms above number 26 through number 26. They were only connected through 26A. And the flats were laid out in a confusing manner, creating a flying freehold. And he had enjoyed 18 years exclusive possession without disturbance. So that is a bit of an extreme case. In Zarbon Parry and in IMG IM Group PLC, the courts also held that a squatter's belief does not necessarily come to an end or become unreasonable as soon as she is put on notice by the paper title owner that the land does not belong to her. Therefore, the reasonable belief can continue even after the squatter has received letters from the paper title owner asserting his title to the disputed land. In Zarbon Parry, Lady Justice Arden said, I'll start my quote a little bit earlier than that bit there. The case was that the Parrys ought to have realized that the southern boundary was inaccurate when they received a letter dated 16th of October 2007 from the solicitors for the Zarbs, explaining the basis on which the Zarbs claimed ownership of the strip, including a reference to Plan B. Miss Collington placed some emphasis on the fact that Mrs. Parry was also a barrister. Picking up that quote there, in my judgment, the belief of the Parrys was a reasonable one to hold. When they purchased Fleet House, the dispute was dormant, as the Zarbs had not raised the dispute in response to Mrs. Seen's communications. The dispute remained dormant for the next 5 years, as there were no communications challenging the southern boundary from the Zarbs until 2007. By that time, they and the Seens had together been in possession of the land for well over 10 years. The report of Mr. Powell confirmed the Parrys' belief that the physical boundaries were correct. Mr. Powell was a qualified surveyor, and he had reasons supporting his opinion. In those circumstances, the belief of the Parrys, in my judgment, continued to be reasonable. Mrs. Collington had laid some emphasis on the fact that Mrs. Parry was a barrister, but she did not suggest that she would necessarily have had a detailed knowledge of this area of the law. So attending this seminar will not assist you if you are in a dispute over your boundary. But turning to practical considerations, it is vital to plead any facts which might be relevant to determining when the reasonable belief came to an end. Those who are seeking to resist the adverse possession should make very clear to set out in detail any conversations which were had, any time that someone was shown a plan, drawing on any advice which was given in the conveyancing process. And those who are seeking to resist, or seeking to make an adverse possession claim and to show that their belief was reasonable, will do well to draw on factors which were relevant in those two cases we've been looking at. So they could look at the fact of the length of the period of adverse possession. If it's well over 10 years, and there's really been a long period in which there's been no challenge at all, then it would be harder to dislodge that belief, as it was for Mr. Chowdhury. For whether there was, as I say, a long period in which there was no active dispute, or in the Zarbon Parry's case, where there had been a dispute, but it had died down and hadn't really been raised again. So they were entitled to believe that it had sort of resolved itself and gone away. Where the position of the boundary is a complex matter, which cannot easily be determined even after inspecting the plans, then that is also a key factor. And as for the Parrys, if you have an expert report which leads you to maintain your belief about the position of the boundary, that will be important as well. So all of those factors are important. Mentioning something which I think was referred to by Gavin last week, it will be impossible to argue that you reasonably believed that that the land belonged to you if, for example, it's a separate unit, occupying a warehouse in a separate in a way which evidently could not be seen as being simply an extension of your property, but is very much a separate unit. That's not possible under the current Act, because the reasonable belief simply can't extend to that much. But it does appear that it can extend to cases where, if you were to look at the plans or the title deeds, it would be quite obvious that you didn't own the land. But where, if you simply look at the boundary features, you could be led to believe that it was your land. So the next practical consideration, where appropriate, the paper title owner could argue that the squatter's belief was unreasonable because she failed to make appropriate inquiries or take advice. So it is important in these cases to argue, well, if there are obvious boundary features or access issues, which should put the squatter on inquiry that the land did not belong to her, then make that point and argue that, well, you should really have taken advice. It wasn't reasonable just to continue assuming that it was yours. And that's especially the case if at any point the paper title owner has challenged the squatter about the boundary or asked her to stop certain acts of possession. The more facts you have like that, then the more likely it is that it was unreasonable not to take advice. And so even though Mr. Chowdhury was not required to take advice in that case, the Court of Appeal did emphasize that in other cases, squatters would be. So Lord Justice Atherton said, what is in issue, therefore, is not imputed knowledge, but rather whether that particular person, here the respondent, was reasonable in holding the belief that he or she did in all the circumstances. That can involve a question as to whether the respondent should have made inquiries of his solicitors or elsewhere as to whether, notwithstanding his purchase of the freehold of number 26A in 1993, the disputed land was in fact comprised within his paper title. So I hope that gives some helpful guidance on this this section of the Act, which is not simple. And I'll allow some time now for questions, if anyone has anything they'd like to ask. Right, so can a squatter ever have a reasonable belief if the extent of the land in question could be brought under the general boundaries rule? So I think that if it falls within the general boundary, then it's much easier to argue that you reasonably believed that the land was not yours. Sorry, that you reasonably believed the land was yours. And the further it gets away from being the general boundary, dispute over the general boundary, into being a property dispute, the harder and harder it is to argue that there is a reasonable belief. There is always a complex relationship between boundary disputes and adverse possession, because if you have a declaration of what the boundary is, then that can amount to no more than a repositioning of the general boundary. So putting the general boundary in a more accurate position, but it's still a general boundary. And so it may be the case that a determination of the boundary resolves the question of adverse possession. But so there's often disputes which will involve both of those elements. In Zarb and Parry, they were seeking a declaration of the boundary and also an injunction requiring the boundary features to be moved. I'm not quite sure if that answers the question, but that I think they are often related. There is also case law that you cannot be in adverse possession of land which you are already the registered proprietor of, and that's another question. But I don't know if that's. I'm not quite sure if I'm hitting the nail on the head with that answer, but come back to me if you need me to. Please, may we have the slides? Yes. Can a squatter of a garage also claim adverse possession of a driveway forecourt? In principle, there's no reason why not, but I think it would depend on the nature of the land in question and the title plan, the transfer plan, because it may be very obvious that the boundary only goes up to the edge of, say, a building and doesn't include any sort of curtilage or driveway beyond that. And so it could be much harder to argue for a reasonable belief. I mean, if I go to my own case, the one that I referred to, there the title plan itself made it quite clear that my clients didn't own the whole of that front garden, but they still succeeded. But that was because the boundary that had been created by the transfer deeds didn't correspond in any way to physical features, or very little at all. It went across the lawn in a very unusual angle, rather than following driveways and so on. So I think that's a very fact-specific question, but certainly it is possible. Next question: if the paper title has installed a fence within the boundary line and makes clear to the squatter by way of letter to say that the squatter only has permission to use the land, is this enough to prevent the squatter demonstrating a reasonable belief that he owned the land? So install the fence within the boundary line and makes clear to the squatter by way of letter to say that the squatter only has permission to use the land. Is this enough to prevent the squatter demonstrating a reasonable belief that he owned the land? I'm not sure if I know where the fence is being erected, whether it's inside the paper title owner's land or outside. But if the paper title owner has exercised control over the disputed land by putting up a fence, then it will be difficult for the squatter to establish that they have factual possession of the land, because the most obvious way of exercising factual possession is by putting up boundary features. So that would possibly prevent an adverse possession claim. And also, if there's a case of the paper title owner granting some sort of license to use land, that can also prevent an adverse possession claim. So that's what I'll say on that one. Next question: you mentioned earlier that the paper title owner might not only lose the land, but also pay costs. In the first tier tribunal, would this be unusual though? It would need to be unreasonable to afford the claim. In the first tier tribunal, with land registration claims, the court will ask the party who is successful to make an application for costs once the claim has been determined, and then the court can make a cost order. As I understand it, it doesn't depend on unreasonableness in defending the claim. The court has a similar discretion as in usual cases, and the presumption would be if you are successful, then you should get your costs. That's in land registration claims. It's different in service charge cases and so on. I don't think there's a requirement of reasonableness. I will check that point again. You have to consult the first tier tribunal rules. But it's my understanding is that it's usually the case that costs will follow the event in land registration claims, which includes adverse possession claims. Okay. So I think those are the only questions we've got. Anything else? I don't think so. So yes, I'm not sure whether I've answered those as in a helpful way, but if there's anything else you want clarification on, please do email me. My email is jaldis, Jaldis, at st-phillips.com. And if you email me as well, I can send you the slides. I think the recording is going to be put on YouTube, so you can listen to it again there if you want to. Well, thank you very much for attending. I hope you have a very pleasant rest of your Tuesday.